Welcome to the Employment-Related Law Training. This course contains information on how to prevent discrimination, promote health and safety, and establish equality throughout the workplace. Employment law is the state and federal laws that protect our worker rights and the organization. Employment law includes employment discrimination, such as the Equal Employment Opportunity Commission, or EEOC, Bona Fide Occupational Qualification, or BFOQ, Americans with Disabilities Act, the ADA, Age Discrimination in Employment Act, ADEA, and Title VII of the 1964 Civil Rights Act. Employment law also includes harassment and sexual harassment, the Occupational Safety and Health Administration, or OSHA, which also includes the Whistleblower Protection Act, WPA. Employment law also includes employee benefits, such as Family and Medical Leave, FMLA, Retirement Income Security Act of 1974, ERISA, and the Consolidated Omnibus Budget Reconciliation Act, known as COBRA. Wages and hour worked are also employment laws. They include the Fair Labor Standards Act, the FLSA, and the Equal Pay Act, EPA. Lastly is workers' compensation. We have the right to be free from discrimination and harassment, in a safe workplace, free from retaliation for filing a claim or complaint against employer, and fair wages for work performed. Employment discrimination. Employment discrimination is the act of treating someone unfavorably because of one or more protected characteristics. No one wants to go to work feeling scared, left out, or overwhelmed by coworkers in the workplace. We want equal opportunity for everyone. The Equal Employment Opportunity Commission, known as the EEOC, is responsible for protecting us from employment discrimination because of race, color, religion, sex, pregnancy, gender identity, sexual orientation, national origin, disability, age, or genetics. There are 3 types of discrimination in the workplace: disparate treatment, disparate impact, and reasonable accommodation. Now let's take a look at each one of these, starting with disparate treatment. Disparate treatment is intentional discrimination and is when individuals in similar situations are treated differently, and the different treatment is based on the individual's race, color, religion, sex, national origin, age, or disability status. An example is providing a higher wage to men than women for the same job. Next, disparate impact. With this impact, intent is irrelevant, and it excludes a protected group from employment activities like employment tests. For example, if you hire based on height and they are all men, you don't mean to discriminate against women. An example is hiring more men than women as construction workers due to their strength. Lastly, reasonable accommodation. This type of discrimination is intentional, and it is when an employer fails to accommodate an employee due to a disability or belief. There is also one exemption, and it is called Bona Fide Occupational Qualification, or BFOQ. This recognizes that in some extremely rare instances, a person's sex, religion, or national origin may be reasonably necessary to carry out a particular job function. For example, such as an actor who needs to show authenticity or nationality in a role. Preventing discrimination also involves avoiding biases. Unconscious biases exist in everyone, and they are hidden beliefs about certain things. This means we can unintentionally treat people differently. We must first acknowledge our unconscious biases in order to do everything we can to avoid them. Additional discrimination laws. The Americans with Disabilities Act, or ADA, is a broad civil rights law that protects workers with real or perceived disabilities from being discriminated against. A disability is a physical or mental impairment substantially limiting one or more major life activities. Another discrimination law is Age Discrimination in Employment Act, or ADEA, which prevents employers from giving preferential treatment to younger workers over older workers. This law only applies to workers 40 years of age and older and workplaces with 20 or more employees. Discrimination employment practices such as hiring, firing, promotions, training, compensation, and benefits are illegal under Title VII of the 1964 Civil Rights Act. This federal law prohibits discrimination in all aspects of employment, including compensation based on race, color, religion, national origin, and gender. The Equal Pay Act of 1964 also deals with discrimination. However, we will go into this a little bit further later in the training, as it also deals with compensation. Next, we have harassment and sexual harassment. Harassment can include offensive remarks such as jokes, slurs, name-calling, assaults, threats, and even offensive objects or pictures. There are two types of sexual harassment. Quid pro quo, and this is when a person that is being harassed must go along with the illegal actions or risk adverse employment actions such as a demotion. And a hostile workplace. These are unwelcome advances that interfere with the worker's ability to complete their job duties. Our employees must understand that there is a zero-tolerance policy for discrimination and harassment in the workplace. Next, let's talk about the Occupational Safety and Health Administration. As a manufacturing company, we must keep our employees safe. This is why the Department of Labor initiated the Occupational Safety and Health Administration, known as OSHA. Workplace safety is high priority, and we must do everything to protect our team. Under OSHA, employees have the right to work in a safe and healthful workplace, know about hazardous chemicals in the workplace, receive information about injuries and illnesses in the workplace, complain or request hazard correction from their employers, receive training about workplace hazards, examine hazards, exposures, and medical records, file complaint with OSHA, participate in an OSHA inspection, and be free from retaliation for exercising rights which are known as the Whistleblowers Protection Act. The Whistleblowers Protection Act, or WPA, is a law that protects those who report illegal or unethical acts with an organization. This also includes wrongful termination. Another major employment law regards employee benefits. In 1993, an employment law was passed where an employee does not have to choose between work and family if a medical emergency arises, often known as the FMLA, the Family Medical Leave Act. This law entitles eligible employees of covered employers to take unpaid, job-protected leave for specified family members and medical reasons. It allows employees to keep their health insurance during their leave. Eligible employees must work for a covered employer, has worked for an employer for at least 12 months, does not have to be consecutive unless it's been 7+ years, has at least 1,250 hours of service for the employer during the 12 months immediately preceding the leave, and works at a location where the employer has at least 50 employees within 75 miles. Eligible employees may take up to 12 weeks of leave in a 12-month period for one or more of the following reasons: the birth of a child or placement of a child, adoption or foster care within the first year of birth or placement, to care for a spouse, son, daughter, or parent who has a serious health condition, for a serious health condition that makes the employee unable to perform their essential job functions or duties, and for any qualifying emergency arising from the fact that a spouse, son or daughter, or parent is a military member on covered active duty or called to covered active duty status. Family members under FMLA are considered to be spouse, child, parent, or someone standing in loco parentis. An eligible employee may also take up to 26 weeks of leave during a single 12-month period to care for a covered service member with a serious injury or illness when the employee is the spouse, son, daughter, parent, or next of kin of the service member. Upon return from FMLA leave, an employee must be restored to their original job or an equivalent job with equivalent pay, benefits, and other terms and conditions of employment. Let's talk about the Employee Retirement Income Security Act of 1974, or ERISA. This is another federal law that sets minimum standards for most voluntarily established retirement and health plans in a private industry. This law ensures employers notify their employees of benefit plan terms, including funding, coverage, and costs. COBRA, or the Occupational Safety and Health Administration, is an amendment of ERISA, and it provides some workers and their families with the right to continue their health coverage for a limited time after certain events, such as loss of a job or reduction in work hours. Wages and hours worked. The Fair Labor Standards Act of 1938 is a major federal law affecting compensation. The FLSA provides regulations on the duration of workdays and breaks an employer must provide. Employers have to keep accurate records of time worked, pay no less than a required minimum wage, set minimum age for employment based on the type of work performed, set overtime pay, set criteria to determine exempt status, and if an employer fails to comply with the FLSA, it can lead to a costly litigation. Now, the Equal Pay Act of 1964, which we mentioned earlier in the training, is another wage law closely related to the Civil Rights Act and EEOC. It is an amendment to the FLSA and addresses gender discrimination concerning compensations for similar jobs. This includes seniority, performance, quality, skill, effort, overall working conditions, and prohibits discrimination in pay based on gender. Finally, we will talk about workers' compensation. This was developed to allow injured employees to be compensated by replacement of income, rehabilitation, and time off of work for work-related injuries. Under the California Workers' Compensation Law, a worker injured on the job is entitled to benefits that include medical care, such as treatment for the injury, temporary disability, which is payment for loss of wages, permanent disability, which is payment for permanent loss of function, and job displacement benefits, which is payment for job retraining. It is important to relay this information to our team so they know the benefits that are available to them. Expectations for our managers. Managerial expectations can have an impact on how well leaders execute their responsibilities. It is our duty as leaders to protect our employees and the organization. We expect each manager to know the basics of each law and relay the correct information to their team. We expect managers to make decisions about health and safety that may affect work activities or other people. We expect managers to ensure legal requirements regarding health and safety are met. We expect managers to provide a safe work environment, provide equal treatment amongst everyone, and provide complete transparency. How these laws protect employees. These laws protect employees and job applicants against discrimination, harassment, and unfair treatment in the workplace by anyone because of race, color, religion, sex, including gender identity, transgender status, and sexual orientation, pregnancy, national origin, age, 40 or over, disability, and genetic information. Being denied of reasonable workplace accommodations for a disability or religious beliefs, retaliation because they complained about job discrimination or helped with an investigation or lawsuit. To conclude, we will talk about how to protect the company. We protect the company when our managers have knowledge around each law and avoid unconscious biases. This training will minimize lawsuits over discrimination, harassment, and unfair treatment towards the organization. These laws ensure employee relations are closely monitored and creates a sense of trust between our team and the organization. This concludes today's training. Thank you.